Good afternoon, good morning, good evening. Wherever you are, we are happy to welcome you in our first edition of this webinar, where we are trying to give you a wrap up of what has happened in the last 1 year, that is 2022, and what is in store for us in 2023. As we all know that this space of law all over the world, including India, has been extremely active, passing through some changing phases of amendments. Our scope of the webinar of today, it's of course 1 hour with Q&A sessions time permitting. Activity hit up, we want to cover that very briefly. Then the second topic for us today would be trends in cartel enforcement, dawn raids, very interesting. Developments in the enforcement of vertical restraints and abuse of dominance. Tech sectors and enforcement highlights, that's very important as we have been getting a lot of traction across jurisdictions. Amendment bill and parliamentary committee reports and outlook for 2023. Today we are having three speakers. All three are partners. Sagardeep Rathi and Pranjal Prateek, both are partners here from our New Delhi NCR, that is National Capital Region offices. And I am Manas Chaudhary along with them. We'll be having two parts of this webinar. One is today and the next one is on 25th, where we'll be happy to join with other partners of the team. So what we are going to take up in the activity hit up in 2022, we will be just walking you through to the only enforcement part of the Competition Act and where the CCI has been actively involved. So when we say enforcement part, we are talking about abuse of dominance, cartels, bid riggings, vertical restraints. All these three are the major limbs of the enforcement activities. What has happened in this space, that in case of abuse of dominance, there were very few cases where the CCI found contraventions. In fact, 35 cases of contraventions were not found, but in case of contraventions, it did find contravention of about 4 cases. Similarly, in the vertical restraints, again, we found 15 contraventions, but only the cases which were finally concluded, that is 1. So if we see the percentage of the number of cases being filed and the number of cases being adjudicated, the percentage ratio in case of abuse of dominance is less than 10%, sorry, and in case of contravention, it is almost less than 1. So that is, I think, the trend across the jurisdictions, that vertical restraints and abuse of dominance are really not much. The most pernicious area of the Competition Act all over the world, including India, is cartels and the bid riggings. Here, the ratio of the contraventions versus the final orders remedying these allegations is 50% nearly. In case of contraventions relating to cartel, 10, and the findings of the CCI were 20, of course, and findings were 10. Similarly, in case of bid rigging, there were 6 cases and 5 were found to have contravened. Can you go to the next slide? So I will be now asking my colleague Sagardeep to take up these 2 slides in little great details as to what we have covered until now. Over to you, Sagar.
Thanks, Manas. Good evening, good morning, good evening, everyone, and welcome to the webinar. Focusing on the cartel trends in the competition space for 2022, what has happened is that the CCI has continued to look at some of the favorite and the more traditional business sectors in India in terms of the investigations that have been initiated. The hot favorite ones of the CCI have always been the cement sector, the tire sector, the Alcobev sector, and also cases in the public procurement space. Cement, I'm sure everyone is aware, is one sector which has been facing heat from the Competition Commission of India starting in 2010, wherein the first ever case was instituted against some of the major cement manufacturers. And it saw a huge amount of penalty that was imposed on 11 companies in 2012. Now, that particular case had gone into litigation time and again, and 2016 and 2017 were the years where those penalties were confirmed, and these cases continue to be pending before various appellate levels such as the NCLAT and the Supreme Court of India. However, it's not just those previous cases. The CCI has continued to see the cement sector as continuing with some anti-competitive conduct, and even in 2020 December, the CCI had conducted, which was the peak of COVID, they had conducted their first ever successful dawn raid in the cement sector. And this investigation continued, and we heard a lot of media reports about a DG investigation report submitted to the CCI in this sector. Again, very recently in this sector itself, what has happened is another dawn raid was conducted in the last month of 2022, which is almost at the fag end of December, wherein some other players in the cement industry were raided. While of course the allegations and the nature of the complaint is not clear, however, it shows that this sector continues to be at the top list of the Competition Commission. Tire again is another important sector which has continued to face heat by the CCI. In December of 2022, the NCLAT, which is the appellate authority, set aside an order of the Competition Commission of India, wherein a penalty of close to about 1,700 crores was imposed on 5 major tire companies. This was remanded back to the CCI for considering on certain issues of arithmetical errors in the CCI order, and also on the fact about the amount of penalty that was imposed, amongst some other issues. Now, this was actually a case which was going on for many years before the commission. However, the order was only passed in February of 2022. This case was involved in certain litigation before the Madras High Court, and also went to the Supreme Court on the nature of the investigation and the way the investigation was ordered. However, eventually the CCI passed this order, which was actually dated August 2018, but only passed in 2022 or Feb of 2022. Now, this was one major penalty that the CCI imposed during the course of 2022. At the same time, in March of 2022, the CCI had conducted a dawn raid against certain tire manufacturers. Some of them were common to both these cases, which pertains to a different investigation which continues to be ongoing. This appears to be a case of bid rigging. However, since the more details are not available in public domain, that's the information that is available. At the same time, this is one sector which has not, it's not the first time that the CCI has looked at tires. Back in 2008, there was a case from the MRTP Commission which had been transferred to the CCI, and this investigation was taken in the initial years of the CCI coming into force, and at that time, due to lack of evidence, the investigation was closed. So these are two hot sectors which continue to see activity at the CCI level. Alco-Bev and generally Country Liquor are two sectors which have continued to see smaller cases that are being filed before the Commission on both cartels and other vertical restraint issues. However, the main case that the CCI has looked at so far was the beer cartel case, wherein a penalty of 873 crores was imposed on 3 beer manufacturers, top beer manufacturers in India. This was a case arising out of a leniency application, and the CCI, after conducting a dawn raid and getting cooperation from all 3 top players who were involved in this litigation, had closed the case in October 2021. Despite the CCI finding a finding of contravention, some of the parties had decided to go into an appeals before the NCLAT on the amount of penalties, and also in some context challenging certain findings of the Commission on the contravention itself. However, the NCLAT, after hearing the parties extensively, has closed the case and upholded the CCI order dismissing the appeals. And the ratio that comes out from such cases that if you have filed a leniency application, it is an admission of guilt, and after that, coming before the regulator challenging that order, the appellate tribunal challenging that findings, is not going to be seen as favorable. So that particular order has been the appeals have been set aside and the order has been upheld. Similarly, a raid conducted in the country liquor manufacturers, local manufacturers in the year 2021. So you can see that this is another sector that the CCI has been actively looking at. Steel seems to be another sector, not many investigations in the steel sector. However, again, similar to tire, the tryst of the steel industry with the CCI started on one transfer of an MRTP case when the CCI was formed. And despite some investigation, the case was closed due to lack of any evidence. However, after that, and that involved there's some big players like the Steel Authority and the RINL. There has been news of a raid that was conducted just in the fag end again of 2022, in December of 2022, in the steel sector, which involves some local steel TMT bar manufacturers. Not much information is available about this case as of now. However, the media reports do suggest that it involves players across India in an allegation of cartelization. Not sure if the big names like the big steel companies are continue to be involved in this. Another, as I mentioned briefly in the beginning of the presentation, public procurement seems to be the key focus of the cartel investigations. If we were to see the number of cases that have been filed before the CCI, a fair bit of them involve cases relating to bid rigging, relating to the government tenders, and this includes cases across industry sectors. A key one also being railway procurement and related sectors. So the trend has been the same for the CCI. The cartels in the traditional markets continue to be equally important for the regulator, and they have been passing orders, imposing penalties, and at the same time also in certain smaller cases, keeping in mind the nature of the industries in MSMEs, have been has imposed lesser penalties.
Sagar,
that's on cartels.
Yeah, Sagar, I mean, all of the audience from these two very important slides have really come to know that there are trends of very strong cartel investigation being undertaken by the CCI and the DG. Can you just walk us through as to what the trigger of dawn raids in India are, and how would leniency and dawn raid are part of this very strong message which we are getting from the CCI? Over to you, Sagar, for this slide.
Certainly. No, I think, as I mentioned, dawn raids has been a very important tool for the regulator in conducting the investigations. And interestingly enough, if we look at statistics, the highest number of dawn raids conducted by the regulator so far has been in the year 2022. It was equally active in 2020 and 2021, despite the fact that there were several lockdowns and we were going through a COVID period when a lot of people were not even present in office and there were restrictions, logistical concerns. But the CCI has taken upped its game on conducting investigations through the dawn raid route. It appears that the regulator is no longer interested in following the methods of calling parties for investigation, seeking information through RFIs and summoning people. It appears they are more interested in gathering evidence directly from the offices of the parties, and the statistics speak for itself. What has happened in the past year, it looks like that the regulator is coming of age. They have certainly been conducting much more advanced raids, well coordinated across the landscape of India. There is no specific sector that they're focusing on. Some of the key hot sectors that I mentioned are the ones that have been looked at by the CCI in this year. It started with tire in March. It moved to the mining industry. It moved to an e-commerce situation as well, which I will come to. And it ended with the steel and the cement sector in December 2022. Now, certainly, there is not much information that comes out when dawn raids are conducted. It was noticed that in December, the CCI itself also published on its various social media pages about having conducted a successful dawn raid in the steel sector, without, of course, naming parties. They had mentioned the certain cities and the number of cities that they conducted the dawn raid in. This was also a first. CCI has never officially made any public statements about the raids that have been conducted. Also interesting to see that another actually interesting sector here is conducting a dawn raid in a non-cartel or a non-section, non-horizontal agreement scenario, which is relatively new, which was in the case of the e-commerce sellers, primarily third-party retailers of big platform players like Amazon and Flipkart. There has been an ongoing investigation against Amazon and Flipkart in the vertical restraint, which is effectively vertical agreement side, in relation to deep discounting, in relation to self-preferencing and preferential listing of products on their platforms. And during the course of the investigation, it appears that the CCI, the DG office, thought it necessary to conduct raids in the offices of certain third parties who are not even under investigation, but are only the resellers on the platforms, on these two platforms which are under investigation. And extensive raids ranging into at least spending 2 days in the offices of these players have been conducted. So this is the dawn raid story. We are not sure if, probably to just answer Manas's point on leniency applications, in the past we have seen that leniency applications are the one that result in the conducting successful dawn raids. However, the trend shows that the DG has decided to use this mode more frequently without even the presence of an admission of guilt. The takeaway, of course, is that dawn raid trainings have become all the more critical for all players. It's not just the basic traditional sectors that need to look at this space. If the CCI can knock the doors of a third party, then clearly it has exercised its wide powers and can knock on doors of any player.
Yeah. So Sagar, that's a very, very interesting departure from what we have so far been seeing in the space of dawn raids are concerned. Until almost this third-party rates which you have raised in the case of sellers of Amazon and Flipkart platform vendors, we have found that there were rates. So from this, I think I would now invite Pranjal to speak about more about the vertical restraints and the orders that the Commission had passed in the last year, as in our heat map we have shown, as to how the vertical restraints, which has of late become very, very important insofar as the digital market and even non-digital markets are concerned. CCI is pretty active on that, which was not the case previously. Over to you, Pranjal.
Thank you, Manas, and thank you for this beautiful segue into the next set of topics. So on the vertical and abuse of dominance side, obviously not very unusual of other jurisdictions as well. Tech has been the dominant theme, and while obviously we have looked at a number of tech cases, and we will discuss some of those here and other issues as well in terms of certain changes to the competition law structure in the country as well. But before that, on the specifically speaking on the vertical side, again, as I mentioned, tech has been dominant, but outside of that, at least one case seems to be of importance here. The Hive-Loop orders, what I call the biscuits cases really. So this case involved, although in that sense, it involved a platform. So in that sense, it was not completely distanced from the tech side of things. But here, a platform which was a B2B FMCG platform was seeking relief against two biscuits manufacturers, very popular biscuit manufacturers, Britannia and Parle. And its grievance was that these two companies were not letting their distributors come on that platform on the distributor side. And therefore, the retailers, which were on the other side of the platform, could not obtain these very popular biscuits. So the case was very simple, that these two biscuit manufacturers have refused to let its products being distributed on the platform so that retailers could have another opportunity or another vertical platform to get access to those biscuits. And we have seen in the past that CCI has looked at these issues, and we have seen some pharma cases where CCI has identified that not dealing with certain distribution players could amount to vertical restraints. But in a departure from those cases, in these two cases, despite the CCI finding market power in the hands of the two biscuit players that we are talking about, said that these two biscuit players will have autonomy to choose the players that they want to deal with or they want to distribute their products to. The CCI said, in a normal course, of course, it will make more economic sense for a player to engage with as many distributors as possible in the market. But when it comes to business strategies, it might be important that it restricts its distribution in certain cases. For example, where it believes that its own distribution network could be harmed as a result of that. And in this case, CCI also recognized the fact that these two companies had invested heavily in forming a offline distribution model. And with this new vertical player seeking almost a positive obligation on their part to deal with this new player would perhaps be an ask which is too much to ask for. And therefore, ultimately, CCI held that because in the market, the biscuit, the product that we're looking at is well distributed, it will not be inclined to hold that there is a positive obligation on the part of these biscuit manufacturers to deal with the platform. So I believe that this is going to have large ramifications, because in some sense, as I mentioned, it is also a digital case because we're looking at a platform here. And in this case, very interestingly, CCI has not appreciated the difference between the offline and online distribution. And CCI, in fact, very categorically saw the offline mode of distribution as a factor which makes the market competitive. So that's very interesting, and I think this case is going to be used on the vertical, on the tech side of things as well. Now, moving more sort of on the tech side, in the thick of things, what we have seen on the tech side is that CCI has adopted a new approach. It is not only imposing penalties and issuing the normal cease and desist orders. It is also now moving on to the, and riding on the bandwagon that we see across the globe, that there is a movement to prescriptive, regulatory approach. And therefore, in the tech cases that CCI has also dealt with in the recent past, we have seen certain prescriptive measures being implemented by or being asked of these players by the CCI. So I want to first discuss the MMT OYO case. Again, this is a case on the online travel agents, part of the digital story. So obviously, MMT, Make My Trip Go, is a large player on the OTA side. And here there were allegations from certain hotel chains, as well as a hotel and restaurant association, that the terms of MMT Go were one-sided, were unfair, And these were primarily based on the fact that MMT Go imposes room price parity as well as room availability parity. So what it means is that not only which is very common in OTA segment, that there is a price parity clause whereby a particular hotel that is listed on the platform has to offer the best rates to the particular platform, and if a lower rate is found elsewhere, then they will have to match the same rate for that particular platform. So that's price parity. And there was additionally room availability parity, and therefore that required that in case a room is made available in another platform, that would necessarily require it to be made available on MMT platform as well. So there was also an additional allegation that MMT Go entered into an exclusive agreement with OYO, thereby it precluded access to the platform to certain other hotels in this case. And what we ultimately saw is that CCI came up with prescriptive direction in this case, asking MMT Go to not impose any price parity at all, or asking other hotels to be fairly getting access to the platform. Now, Google order, I will come to that very quickly. There's a separate section dedicated to that. But one interesting point from all of this is that when they are going in appeal before the National Company Law Appellate Tribunal, the Appellate Tribunal surprisingly is only, while admitting the appeal, staying the penalty part of the order and not staying these prescriptive measures that have been imposed by the CCI. And that's very surprising, and that could be very alarming, because some of these prescriptive measures attack the very business model on which these companies thrive. And therefore, if the NCLAT does not give a stay on that, that ultimately means that these companies will lose the entire business model that they are sort of working on. Now, quickly coming to the Google orders. Google orders, again, there have been two large cases here, and what happened in this case was that Google has its own mobile OS platform, and there were allegations that OEMs or mobile OEMs do not get access to the platform unless they sign a host of agreements, and that includes bundling of a lot of Google's other apps. And one of the preconditions is that those apps must be pre-installed in the phone if an OEM wants to have a meaningful use of Android on their phone. And that has, of course, led to a lot of issues, and ultimately CCI giving again prescriptive measures that these should be freed. The OEM should not be required to completely to deal with the entire bouquet of Google's app, and it can pick and choose some of the apps that it wants to be pre-installed. There was another investigation on obviously the payment side, and that also led to certain penalties, and as well as prescriptive measures there as well, that these payment, the Google should not force its own billing system to be used while making payments on the Android Play Store, and other mediums should also be allowed. And not only these cases, CCI has also used a multi-pronged approach, and it has also come up with certain market studies. It has done so in the tech sector. There has been a recent cab aggregator sector. We don't have the time to go into the details of what those market studies were. Probably it's a topic of another webinar altogether. We can go into that some other time. And not only Google and not only MMT, there are a host of cases that are pending before the CCI. Apples and Amazons and Flipkarts and Zomato and Swiggy's of the world all are facing investigation at the moment. Over to Manas.
So, okay, thank you very much, Pranjal. These are, actually, they are webinars in itself. If we want to talk about tech, and if we want to talk about the cases in the tech sector, there are many issues which we need to cover, which is, of course, it's only a snapshot as what we are trying to do here. So from here on, I would just like to give an overview of as to what we have earlier spoken about, as to what the regulatory architecture is proposed under the new Competition Amendment Bill. This bill was placed in Parliament after a lot of deliberations right from October 2018, when this CLRC was constituted by Ministry of Corporate Affairs. Thereafter, the members of the CLRC had gone clause by clause as to what the amendment should look like in future. A bill was presented on 13th of March 2020, which ultimately was being put to stakeholders' comments. Thereafter, this has been brought down to a bill, and the bill was again subsequently been finalized and placed on 5th of August before the Parliament, that is the House, Lok Sabha. And then on 17th of August, the Chairman Lok Sabha had directed that this bill may be sent to the Chairman of the Parliamentary Standing Committee on Finance, and led by Mr. Jayant Sinha, the Honorable Member of Parliament, Lok Sabha, who had deliberated upon this bill, and thereafter a Parliamentary Standing Committee report was brought to public domain on 13 December 2022. Besides these two limbs, that is, one is the amendment bill and the Parliamentary Standing Committee's views and recommendations on the bill, we are also having a new competition practice, anti-competitive practice in big tech sector, which is likely to be also considered as perhaps a new law from within the perspective of the big tech sector and competition overlap. And that I have already shared with all of you in the earlier segment of our opening remarks, that this is a trend globally and India is not lagging behind. Next slide, please. Yeah. So giving a brief overview as to what the Competition Amendment Bill and the Parliamentary Standing Committee key amendments proposed look like, we are having two slides. Just very briefly, because it is not possible to cover the entire proposal and the Parliamentary Standing Committee recommendations in this seminar, we are trying to give a snapshot. One is that I'm focusing currently only on the enforcement side of the amendment bill. We will be parking discussions relating to merger control in our next seminar on 25th of January. What we are trying to focus here is that in the vertical restraints, that is the relationship in the distributor and the manufacturer chain or in abuse of dominance cases, the bill recommends that there should be a settlement or commitment options available to the respondents who can come before the CCI at different stages, either at the stage of the prima facie view has been formed with the DG being directed to investigate. A settlement application can be filed by the party who believes that by way of a filing, it can end the litigation, and it is indirectly admitting that it is not really going further with the alleged breach or the contravention of the Competition Act. The other area is that in case of an investigation being completed and before the CCI can pass a final order, the parties can still have an option to file a commitment application that, yes, I'm going to give this commitment so that no final order is passed adverse to my interest. However, the settlement and commitment are not the way the parties file will be agreeable to the CCI in its form and the language. The CCI will have to look into it based on the evidence available with it and with the DG, and thereafter it may take a decision as to how much of it should be allowed and how much should not be allowed. So that really opens up the discussion whether or not parties should have a right to appeal. And there again, the law is silent, the amendment bill is silent as to whether or not parties will have a right of appeal against an order which may not be the original objective of the party filing the settlement or the commitment application. That's one area which I think as the time unfolds, we will come to know what the law takes shape by way of an evolution. The second area is that the Parliamentary Standing Committee believes that the settlement and commitment must be having some kind of a procedure whereby admission of a guilt relating to cartel can also be brought in. There, we also have some views as practicing lawyers, because we are aware that in case of cartels, we have got a scheme of leniency applications or a lesser penalty regime, whereby the parties in a cartel can always file almost admitting guilt. So whether this additional settlement commitment route for an admission of a cartel, whether that would also go way along with the existing regime of the lesser penalty available under the Competition Act. So these are things which are likely to unfold as we go forward. The leniency plus is an additional thing which we already have. We can call it a lesser penalty plus. So what happens in that is that the party who are involved in a cartel, they can also admit involved in another cartel. And that is where, you know, the parties may get some kind of an additional benefit in their first cartel. So let us see how this shapes up, but the enabling provision has been introduced. Facilitators of cartels or buyers, hub and spoke, buyers cartel, these are all included in the bill. The Parliamentary Standing Committee recommends that there should be an element of intent to be identified before really these facilitators can be brought into the role of the cartels. That is where, you know, we may have some reservations, because end of the day, in case of hub and spoke or a trade association related hub and spoke situation, the intent has never been the case until today. With the intent being introduced, there can be a scope of as to how one would really specify the intent, because intent typically is an area where we are actually trading into the criminal legislation part of it. Whether that can really overlap with the mens rea kind of a situation, we'll have to wait and watch as to how this intent can be brought within the ambit of this particular aspect of the new amendment bill. The other areas which are very important for all of us to understand, the capacity of the conduct of the focus on the recent conduct impacting competition, reduce CCI's regulatory burden, and computation of limitation period. These three are, we would like to really see how the total amount of time involved in case of a party preferring to go before the CCI. So they have introduced a very long-standing situation which parties have claimed before the appellate tribunal with regard to a period of limitation. So now the period of limitation has been specifically introduced in the enabling, as an enabling provision in the amendment bill. It is a 3 years period. That means the cases which have been unnecessarily investigated for over the years and ultimately ended on the ground that the continuance of the anti-competitive agreement did not survive, and hence the matter is closed. So with this limitation period being introduced, there is a possibility of such unnecessary investigation and cost to the client on litigations will end. That's a very positive development with regard to that. In case of penalty and then preferring an appeal before the appellate tribunal, the law says that 25% of the pecuniary penalty will have to be deposited before the appeal is admitted, which may be, as we go forward, look quite burdensome to the industry. But we have to wait and see whether this would also entail the CCI to think not to impose huge penalty, because the law says up to 10% or up to 3 times of the profit. Naturally, that up to gives lot of scope to the CCI to consider it in a manner so that this 25% can be mitigated by way of a final computation of the penalty. The DG's office is proposed to be subsumed in the CCI. Why I'm saying subsumed? Because the appointing authority of the DG under the amendment bill would pass on to the CCI. Hitherto, it is the Union of India. Hence, there can be some kind of an overlap between the investigator and the adjudicator. We have to wait and see. So with this, I will now ask Sagardeep and Pranjal, between two of you, to take up the Digital Competition Amendment Act, or the Amendment Act relating to the digital market, which is also the report is in the public domain. Over to you, Pranjal.
Thank you, Manas. And now we're touching upon the Parliamentary Standing Committee's report on the big tech. And this was a topic, first of all, very laudable of the Parliamentary Standing Committee to on its own motion, discussing this topic, because this was not part of any referendum to the Parliamentary Standing Committee. It was part of its annual agenda, and as part of its annual agenda, it picked tech as one of the sectors that it would want to look at. So through the year, not only the standing committee has looked at the competition amendment bill, but also this, and completely separately. So on this, my overall impressions of the report is that this report is very aggressive. That is the least to say. And the Parliamentary Standing Committee seems to have relied on a lot of literature that we have seen also being used in some of the Commission's decision, and therefore in a lot of things they are speaking the same language. Therefore, in terms of tech regulations, the Standing Committee seems to have been completely convinced that the line that the Commission has been taking on its tech enforcement in its cases is the right line, and therefore that's something which is very clear. To me, it appears that some of the issues have been dealt with very simplistically, and that therefore raises the issues of has the Commission looked at all the surrounding circumstances and all the different nuances that can visit such a important topic. And some of the, for example, we look at, so these are 9 out of the 10 anti-competitive practices that the Parliamentary Standing Committee came out with, and these are all based on the CCI's past cases. So we have not, I think, highlighted killer acquisitions or M&A part of it, because obviously that's part of another webinar. But looking at these, the report in a very simplistic manner suggests that these are the kinds of conduct that happen in the tech sector, and therefore certain entities which assume that kind of size and which are technically referred to as the systemically important digital intermediaries or the gateway platforms. So those have been simply asked to not engage in any of the category of practices that are mentioned here. So I think that the report has a very simplistic stand of things, but I'll leave it to Sagar to take on from here and probably discuss some of the terms in greater detail here. Sagar, you.
Yeah. Thanks, Pranjal. No, I think you spoke about CDs. Effectively, what's happening globally is that because of the existing framework of the competition laws, it's most exposed, and the fact that all these digital markets today continue to be looked at in the exposed law scenario throughout the world, wherein if there is a violation, the regulators will look at that in the existing framework, and it will take its own time to find the fact specific issues and come out with its findings and maybe then impose penalties. Is that helping the economy? Is that helping control the growth of some of the bigger digital players? Is a question that's been asked globally, and in order to sort of address that, what's happened, not just from an Indian Parliamentary Standing Committee perspective, even in Europe and the UK, what the regulators and the legislators have looked at, having thought or probably thinking of having an independent regulations for the digital players, which is effectively going to have an ex-ante framework wherein some of the key big players will already need to follow certain set rules and regulations and also comply with them in order to ensure that they don't end up violating or impacting the market economies. Now, as a first step to that, what the government has, the report has suggested is the identification of these CDs, which is effectively, as Pranjal said, some of the important digital intermediaries, or who are called the gatekeepers, digital gatekeepers in the context of EU law, which are effectively the bigger digital players, intermediaries who are able to impact and connect a large base of users to the business entities, wherein it will help identify which are the bigger players who will need to be regulated in the ex-ante framework. CDs basically are going to be entities which will hold position in the market, that so that they can impact entry of new players, hinder the growth of existing smaller players. And as I said, the real test will be the players who are able to negatively impact the market. Now, one key criteria could also be the revenue and the number of active users on a particular platform, or their market capitalization, which will probably be key factors in ascertaining who these big players are. These big players are intended to be regulated through something called the Digital Competition Act, which is effectively one of the recommendations under the Parliamentary Standing Committee's report. And when of course, they have felt the need for having a separate sort of a regulation for the digital players. Now, how this Digital Competition Act will work in the digital ecosystem is something, or what the larger the legislation will entail is something to be seen, because right now the recommendations are limited to certain aspects of how they need to be governed. But what is also seen is that this is somewhere similar to the position that the EU and the UK have taken, wherein there is something called the Digital Markets Act, which has come in and will of course be applicable in the EU this year onwards. Very similar concept, as I said, gatekeepers versus cities. And similarly, in the UK, the existing regulator, that is the Competition and Markets Authority, has also published certain guidelines in terms of having a separate task force within the regulator to look at the digital conduct. Now, one key recommendation also is having some sort of an annual compliance by these cities reporting into the existing regulator. How that will work is something will need to be seen, but one way that it could probably be looked at is through creating a digital markets unit, which is another recommendation that has come in from the Parliamentary Standing Committee. This is some sort of a unit that will be created within the regulator, that is the CCI, and the committee has recommended that there are experts that are hired by the regulator who are skilled in the digital market space, and academicians, even lawyers, who can closely enable the Commission to closely monitor the workings of these cities, and also review the compliance, the annual compliance that these cities may have to make in terms of the regulatory and the digital regulatory framework. Interestingly, only in October, before the former chairman had retired, he had referred in one of these public conferences that the CCI is already working towards having a separate unit within the regulator, which will focus on looking at all these digital market cases. So this sort of dovetails with how the Parliamentary Committee report has made key recommendations, having such a unit which will be responsible for looking at these the digital players going forward. So there's a lot to watch out for from a Digital Competition Act perspective on how this legislative framework will come in place, so if the key recommendations are accepted, and then how this will effectively be put into practice. Back to Manas.
So, Sagar, a very interesting update. As practicing lawyers, we have been seeing that whenever there is an investigation being initiated by the CCI insofar as the digital enterprises are concerned, more often than not, we have seen that there had been a constitutional writ with regard to as to whether or not the CCI has jurisdiction to really look into the digital enterprises and in relation to their alleged anti-competitive conduct. The Supreme Court, until the level of SLP, has upheld that the CCI does have the jurisdiction. So therefore, what I feel as of now, that the settled principle insofar as the jurisprudence is concerned with regard to whether or not CCI has the jurisdiction under the existing competition regime, it is settled. And Supreme Court being the highest appellate authority even under the Competition Act, the decisions of the Supreme Court, even if it is coming through an SLP, is binding upon the CCI. Dovetailing that with this Digital Competition Act, as Sagar just had enumerated briefly, we are going to see a lot of things which is coming in 2023 onwards. So one of the areas which I feel I should be covering the first two, and then I leave it to Sagar and Pranjal to cover the other two. The Competition Amendment Bill of 2022 is expected to be definitely likely, I can only say likely, to be passed by both houses of the parliament and get the presidential assent soon. And it would then add more teeth to the competition agency, perhaps with certain caveats that the DG and the CCI will have overlapping jurisdiction in investigation and adjudication. Penalties with 25% deposit would be another area of concern. These are some of the issues which will unfold. And the last point in my kitty is that with the departure of the previous chairperson, who had done a great job for the last 4.5 years during his tenure, demitted office on 25th October 2022, and we are still having to wait for the new chairperson and get the quorum completed. Until that time, the CCI is busy in engaging with the other non-enforcement activity of the Competition Act, which is advocacy, and we have been seeing the CCI is going all gun blazing, advocating the competition law to various stakeholders, which is another wonderful development to share with all of you, because with their occupation in the adjudication and merger control, they were not able to do that kind of an advocacy as they are doing currently. Over to you, Sagar.
No, I think one more trend to look out for in this year is from something that I spoke about in the beginning on the regulator's powers and how the regulator, the Director General wants to use that power in terms of dawn raids. Since we've seen an uptick in dawn raids over the past years, since 2016 when the first proper raid in a cartel case was conducted, and 2022 being the maximum number, I think we will see a fair bit of increase in this activity. I think the regulator has found this to be more effective in some ways, and having developed a good system and an effective coordinated system within the Director General's office, it's likely to see that sort of an enforcement mechanism, and they're only going to go aggressive and grow on from how they've done in 2022.
Yes, Pranjal.
Yeah, so continuing on the tech theme, as Sagar also discussed and Manas mentioned in the beginning, if the Competition Amendment Bill is ultimately passed, that will obviously mean more enforcement on other side, particularly from a merger control perspective, that might have more impact to tech industry. But if the Digital Competition Act comes into being, and I think it's promised that probably by monsoon session we might see a draft as well on that. So that can, if that then is legislated, that can indeed mark a paradigm shift on how these the tech players operate in the Indian market. That will mark a massive shift. There will be a lot of compliance burden on these tech players. And at the first place, how how the exercise begins of CCI starting to designate certain players as cities, that itself will sort of create a lot of uproar, and it will go through a lot of at least a lot of noise around the entire issue. So let us see if this year also marks the beginning of a new digital enforcement journey. And on the other hand, if we don't see these two paradigm shift happening, then perhaps on the state of affairs as is today with respect to the Competition Act in hand, we might probably see a little bit of loss of traction in digital cases. And this thought probably emanates from some of the news that we have heard from the recent past. And there's some news that certain government quarters, there might be a little bit of displeasure on how the CCI has sort of exercised very far-reaching powers in laying down the prescriptive remedies in the Google order, for example, and other cases. So and as we can already see that at the appellate tribunal, if you don't get a stay and you sort of running pillar to post and going to the Supreme Court to get a stay on the remedies asked for, probably it can massively and irreversibly impact those players. So I think at some level there will be a little bit of course correction, probably until the time we see the new legislations coming in. We believe that there could be some slowdown in the enforcement of tech sector, at least in the current form of legislation.
So with this, I think if we do not have any questions from the audience, we may wrap up because we are within time. We are just 2 minutes away from our time. But if there are questions in the chat box, we can take up 1 or 2. Otherwise, we'll be definitely answering them through our emails if we get their emails, so we can respond to them. Otherwise, I think we can close. If last any thought-provoking question comes up to the mind of Pranjal or Sagar, we can ourselves share those with the presentation coming to an end. One question comes to my mind that if the third parties, as Sagar highlighted in the case of Amazon, Flipkart, their third parties were being downgraded, will that trend be giving rise to some kind of an additional challenges, both to the parties as well as to the appellate authorities? Because if the DG continues to cause the downgrades, obviously the CCI will have evidence to see on merit. But then the question arises whether procedurally will that be a question for the parties to prefer appeal or anything relating to agitating in the higher authorities. That is one area. I think we need to look into that. And if Sagar and Pranjal would like to give some ideas with regard to that, because end of the day, it's not that the Competition Act is here to discipline the industry. It is there to remedy the market effects and the defects relating to market effects. Nothing really to harm the way the efficient businesses run. If the businesses are run efficiently, perhaps the need to an interference by any authority, much less competition authorities, not the rule of the law, especially post amendment of the Competition Act as well as adoption of economic liberalization 31 years before. So all of this, is the questions coming up to our mind. Sagar, Pranjal, before we wind up, we are on time to wind up.
I think it's close to the webinar, but I can just probably say I think the regulators has wide-ranging powers, and certainly irrespective of the nature of investigation, they can certainly use those powers to go in and investigate. Litigations is something that can certainly happen in certain cases, and there are parties who may think that this is overreaching the powers and unnecessarily causing trouble to a person who's not even being looked at as under investigation. Probably could knock the doors of the courts, but the regulator seems to be within his powers to go out and seek information whichever way they want to within the confines of the act.
I think we are hopelessly out of time now, so I think we should close. Thank you, everyone. Thank you for your time.
Thanks everybody.
Thank you.